Did the Karen Reed jury really find her not guilty of second-degree murder?
If so, then doesn't double jeopardy apply?
What's going on here? Could it be that the jury really came to an agreement? I'm Lainey Law.
And I'm attorney Andrew Myers.
Today we have attorney Yoli Medina with us. Yoli, how are you doing today?
Fine, thank you. Thanks for having me again.
We love having you as always. So we have some new developments. So as we left off, I'm sure everybody was familiar with the fact that during the Karen Reed trial, we got our beautiful jury note that said, we can't come to the decision. And now it's turning out maybe they did come to some decisions. Maybe they could unanimously agree on some things. So, Andrew, what exactly is going on right now?
Well, it's a little bit crazy, but let's before we get into the motion and the affidavits, which is where in my view the real action is here. There were 3 charges against Karen Reed. The first count was second-degree murder. The second count was motor vehicle manslaughter while driving under the influence, and the third count was leaving the scene of a collision causing death. Well, all we know is that there was a note, and the judge declared a mistrial. Everybody went home. It was the 4th of July. But wait a minute, hold on. Now, the defense attorneys have filed a motion with affidavits saying the jury was unanimous in an acquittal on count 1 and count 3. The only thing they couldn't make up their minds on was motor vehicle manslaughter, and that was the thing they were hung on. And while I bring that motion up, Yoli, that's a little bit crazy, isn't it?
I don't even understand how this could happen. I just don't. It's insane, because I thought she was supposed to hold them and make sure that she had everybody's, decision on each of the charges. So I don't know what's happening here.
Well, I would think that if they had at least 2 out of the 3, like a decision made for those, that something could be done about that. I wouldn't think that just because the one is missing that would become such an issue.
Well, let's launch into this. I always say the action in these things is in the footnotes. In this particular motion, it was defendant Karen Reed's motion to dismiss, but the facts are all laid out in 2 affidavits. So the first affidavit is that of Alan Jackson. He points out, 1, he's a partner in a Los Angeles law firm. We know that. Number 2, on Tuesday, July 2nd, 2024, I was contacted by Juror A, true name and identity withheld to maintain anonymity. Based on my conversation with Juror A and that juror's description of who he, she is, where he, she was seated, and certain identifying information, name and occupation disclosed during the voir dire, I was able to positively identify which juror he, she was. So some other people have kind of buried this, and it is deep in the papers. But this motion to dismiss is based in part on direct conversations between Juror A and defense attorney Alan Jackson, who in paragraph 3 says that Juror A told me that he, she was seeing inaccurate reports about the split among the jurors related to the mistrial that the court declared the day before. And oh, by the way, the media, especially the YouTubosphere, was kind of rampant with all kinds of rumors. Didn't you? And we'll get it in the comments. Didn't you hear the vote was 2-10? Yeah, I heard it, but it's not supported by any facts. The facts are paragraph 4 in Alan Jackson's affidavit. Juror A stated that he, she wished to be respectful of the privacy of the deliberative process, but did wish to inform me, Alan Jackson, of the true results of such process. Juror A indicated that he, she believes it important to disclose such results because he, she believes that those results significantly impact Ms. Reed's rights. Well, yeah. Juror A told me, Alan Jackson, that the result of the deliberations was that the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic that count 1, second-degree murder, was, quote, off the table, unquote, and that all 12 of the jurors were in agreement that she was not guilty of such crime. Juror A told me that shortly following that determination regarding count 1, the jury also unanimously agreed that Karen Reed is not guilty of count 3, leaving the scene with injury or death. On July 1st, 2024, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated that the jury was at an impasse. 8. Once the jury was seated, the court then read the jury note verbatim in open court, and this is really key, Yoli. Without providing any opportunity for the defense counsel to be heard, the court declared a mistrial and excused the jury. 9. Neither Ms. Reed nor her counsel consented to the entry of the mistrial. 10. Defense counsel was denied the opportunity to request that the court inquire on which count or counts the jury may have been deadlocked, including lesser included offenses, and on which count or counts the jury may have arrived at a verdict. 11, nor did the court on its own inquire of the jury for a person on which counts the jury was at an impasse and whether the jury could or did reach unanimous agreement on any of the counts. 12, had the court so inquired, it appears clear that not guilty verdicts would have been recorded for counts 1 and 3. Ms. Reed was denied her right to receive those verdicts in her favor. And then the rest is just, this is true and correct, sworn under the pains and penalties, et cetera, et cetera, et cetera. But, Yoli, that I've never seen anything like this in 30 plus years of practicing law. Have you?
No. And I've never seen anything like this. And it frightens me because if this is a high profile case that the world is watching, not just the United States, but the world, and this is happening, imagine what's happening to other cases where we're not watching, where it's just a defendant who is just on his own and nobody's watching, nobody's looking, nobody's on the judge's every word. Nobody's hanging on the judge's every word. I mean, even I was hanging on the judge's every word when the mistrial was declared, but it didn't occur to me, or maybe I didn't think of it, but she's supposed to find out which charges they are deadlocked on, because that
was never done.
Because that could help resolve the impasse if she knew.
And would the Commonwealth be so adamant in their immediate declaration that we will try this case again? And that's what they said. Now, if it was true, and if it came out that Karen Reed was acquitted on the big count, count 1, second degree, and count 3, you think Michael Morrison would be so adamant about trying the whole case over again when it's just the second count?
Well, he wouldn't be able to, because if he knew about the not guilty on the second degree charge, then that would be double jeopardy. So he couldn't.
Yeah.
So that this is just outrageous. I'm very, very concerned about the state of our judicial
Lainey,
affairs.
while I find the other affidavit, while I paw through my papers and find the other affidavit, I'd love to know what your thoughts are.
Well, I'm actually gonna pull up, or actually have it right there. The point number 10 on this one, where it says on which counts or counts of juries may have arrived at a verdict. I don't know exactly necessarily the process behind it, but I forget the name of the exact position, but the person who helps the juries, the person that's in charge of making sure that the jury has everything, you would think that obviously the judge doesn't really know what's going on in the jury room, but that somebody else would have had that foresight to, when passing the note, have that communication of, okay, we have points 1 and 3, but we're a little stuck on number 2. The fact that it's just passing the note and then that was the end of it, especially when you say that with all these charges that they should have, been more paying attention. It's just interesting, like, that they would just assume that nobody was able to come to a conclusion on anything is the default assumption. Yeah,
that's the central point here. When they just had that note, which was a general note about their moral convictions, et cetera, et cetera, et cetera. it's kind of odd that there was nothing asked about, well, what about all the counts? So let's take a look. We've only talked about one juror. There are two other jurors, and some say, well, maybe it's hearsay, maybe it's not. But let's take a look at the affidavit of David R. Yannetti in support of defendant's motion to dismiss. I, David Yannetti, do hereby depose and state that the following is true to the best of my knowledge and belief. I am an attorney licensed in Massachusetts since December 20th of 1989. Interestingly, that is the same day I was sworn in as an attorney in Massachusetts in the Great Hall of Faneuil Hall in downtown beautiful Boston. Anyhow, I digress. So he points out that he is the attorney for Karen Reed. On July 3rd of 2024, I received communications from two different individuals, hereinafter informant B and informant C, who had received information from two distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury in this case. So if you think it's hearsay, which I did at first, let's bear with the affidavit. To my knowledge, informant B and informant C do not know each other. On July 3rd of 2024, informant B sent me a screenshot she had received from someone hereinafter intermediary B, the plot thickens, of text messages that intermediary B had received from Juror B. In that screenshot, Juror B texted the following to intermediary B: it was not guilty on second degree, and split in half for the second charge. When the judge sent us back with that Hernandez SIC thing to look at the other side, it turned into a bully match. I thought the process, and Yoli, I think you were telling me the other day that you've heard juries yelling and screaming at each other,
Yes.
haven't you?
Mm-hmm. Yeah.
I thought go ahead. I'm sorry.
Yeah. In the jury room, when they're trying to make a decision, they get angry and they start, but eventually.
Especially after 20 hours.
Oh, yeah. Yeah.
Okay. I just want to get that so we can read it a little bit better. Okay. When the judge sent us back with that Hernandez thing, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose, SIC. They gave us free counseling forms when we left. I could use some counseling after just following dates.
Well, I wonder if they gave him counseling forms because they were arguing in there and it was traumatic, or if it was because of the case itself.
I was wondering, is that like a normal thing? Like, I don't think so.
Yeah, because I've not had criminal trial experience ever, so I don't know.
I've done a little bit, and I've, this case was unusual, though. I mean, how many cases go on for 2 months? How many cases have over 600 pieces of evidence that are admitted, and how many cases have 74 witnesses? So I think I would need counseling, and I don't mean to disparage anyone. Please don't comment and say I'm disparaging anybody that does counseling, because, I'm not. Okay, so where was I?
I don't know if we got 5.
Did we do 5?
On July 3rd, informant C contacted me to say that she personally knows Juror C, as they used to work together. Informant C and Juror C also have a mutual friend, hereinafter intermediary C, who is a current co-worker and friend of Juror C. Informant C told me that she had posted something about the Karen Reed case on Facebook on Monday, July 1st, 2024. She told me that she believes that post led intermediary C to text her and inform her that Juror C was a deliberating juror on the case. So I guess was. During the pendency of the case, you can't talk about it, but I guess when it's all over, I guess there's no reason why you can't. Informant C told me that she thereafter reached out to Juror C via text message and discussed her experience as a juror in a very general term. They discussed what an exhausting experience it was, and that Juror C was relieved that it was finally over. There's your need for counseling right there. Intermediary C told informant C that, are you following this? Intermediary C told informant C that Juror C would be participating in a Zoom meeting with a number of friends to discuss what happened in the trial. Today, informant C sent me 3 screenshots of a text message exchange. So this is what kind of takes it out of the questionable realm of, well, it's only hearsay if these are valid text messages. Screenshots of a text message exchange that she had with intermediary C. Informant C told me that intermediary C was reporting to her during this exchange what juror C had revealed during the Zoom meeting. The text message exchange read as follows: no consideration for murder 2. Manslaughter started polling at 6-6, then ended up deadlocked at 4 no, 8 yes. She was very consistent in the fact that they could only consider things that were admitted into evidence. Ultimately, she voted no because the cause of death was twofold of hypothermia and head injury, of which she was convinced that the vehicle did not cause both. That's interesting. The whole jury felt intimidated by Higgins' presence at the end. She's not sure what she's going to do. She's going to lay low for a couple of days and see where it takes him or her. Hasn't ruled out anything. The jurors all have a group text going. Interestingly, if it was no consideration for murder 2, shouldn't she have been acquitted on that count and hung on the remaining charges? Goes back to the jury verdict slip that was all. Look at this. The juror, and this is memorialized in a screenshot, saying that the jury verdict slip was confusing.
Yeah.
She should have been acquitted, I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. What a great experience for him or her. Amazing that they let the Alberta in the last day. She felt very honored to be part of it. She was redacted. Physical description of juror C. Everybody else was from a professional walk of life. They all got along and never heated. They agreed to disagree and respected each other. Wait, why can't the whole world be like that?
I know.
That's the way it should be. Knew it was an intelligent jury. They will be studying this case in law programs for years to come, how not to investigate and try a case. Oh, and by the way, if they all agreed on no further... if they all agreed on no for murder 2, they should make that clear to the DA and the court. It's basically a case of double jeopardy if she is reached. And that's the whole point, isn't it, Yoli?
Yes, it's crazy. Well, first of all, I was very confused as to why they could not reach a verdict because it said based on their convictions, deeply held convictions. Now I'm thinking, well, was it on which count was it that they couldn't agree on? And now we see that it was count 2. Is that right?
Yeah, and here's the language. Here's the language that you're talking about. It was a sincere adherence to our individual principles and moral convictions. That's that language that to you and I both was really troubling. And yeah, the answer to your question is, according to juror A, and it's not so clear with B and C, but according to all 3 of them, there was a unanimous not guilty on second-degree murder. And according to juror A, there was also a not guilty unanimously on leaving the scene of a collision causing death. So the only thing that they were undecided on, and they're called a hung jury, was count 2, motor vehicle manslaughter while driving under the influence. So yeah, I had a hard time with that too.
So they were. So go ahead, Lainey.
No, you go. You can go first.
Oh, the driving under the influence. I wonder if that was one of the moral.
That's
one
what
of
I
the
was thinking.
moral things that they thought was no, she was driving under the influence. But if she didn't hit him, the driving under the influence is irrelevant. If she didn't hit him, so they have to prove that she hit him. And cause some injury or death, right?
I guess that's a good point.
Just to play devil's advocate to either one of you, why would your moral convictions preclude you from finding someone guilty of drunk driving?
Because if you had one drink, you're drunk, like you're still intoxicated,
right?
Even if you're under the limit, is what they would think, presumably.
But what I'm saying is, why
would it preclude?
what possible moral conviction could you have against finding somebody that's in that position guilty?
Mm-hmm. Well, I'm thinking that they couldn't say like, because I'm thinking because they knew that she was at the bar, so I'm presuming that the moral conviction could have been like, oh well, she shouldn't have been driving anyway. You have one drink. It's just like that's what led to this accident. Where it's just like even if like they were under the limit, I think that's what the moral conviction would be, is that she should have never gotten behind the wheel of the car after having had a drink. Is what I'm
All the more
thinking.
that they, so all the more, I don't see how a moral conviction should keep you from finding somebody like that guilty. I would think that, I don't
It's
know.
right. It wouldn't keep you from finding it. It wouldn't keep you from finding someone guilty of that. It wouldn't. It would be the other way around. It would be that they want to find her guilty because she was drinking.
Mm-hmm.
Let's take a look at the language that they wrote in the argument. And the motion to dismiss, here it is. The motion to dismiss starts out with some very strong and obvious language that, the Constitution of the United States, and here in Massachusetts, Yoli, we call it our declaration. We don't call it the state constitution. We call it the state's declaration. But they point out that the right to a trial by jury is sacrosanct, and it goes way before the United States, codified these things in our constitutions. So they go on. It's really obvious stuff, which I've seen other people spend a lot of time reading it. But what the defense attorneys are saying is, here the very day after a mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors, indicating in no uncertain terms that the jury had a firm 12-0 agreement that Miss Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the second degree. Given the central importance that acquittals have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Ms. Reed on counts 1 and 3 and mandates dismissal of those charges. Alternatively, to the extent the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue, and that the court authorizes defense counsel to seek additional proof from the jurors regarding their having unanimously acquitted the defendant of 2 of the 3 charges against her, prior to indicating to the court that they could not reach a verdict on the 3rd charge alone. So I'm going to stop there, because that's kind of monumental in its importance, I think.
Yeah, and it's just it happened right in front of everybody's face. I mean, nobody thought. Well, maybe Karen Reed's attorneys thought, but nobody thought to. Like, I didn't think she should. I thought she should pull them, but I didn't think about the 3 charges that they could have been hung on only one.
Well, when I first started reading this motion, I'm scratching my head because I thought I had remembered that when one of the notes came out, the judge did in fact ask the attorneys, but that was note 3. After note 4, let's take a look at it. After note 4, the one we're talking about here, she absolutely did not give them a chance to talk about it. Let's take a look at it again.
Mr. Foreman, I am in receipt of your note. Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable
Yeah, we've heard all this.
doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges.
The charges. The note says the charges. So
Plural.
am I reading too much into that to think that what the note implies is that they couldn't reach a verdict on any of the charges?
Now, this is note number what?
This is the last one. This is the
The
final
last
one. Right before you're going to see in 2 seconds. This is the final note for that was the one that she read and then didn't give the attorneys a chance to say anything, and then declared a mistrial.
The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that.
See, she doesn't take the note, and this is Yannetti and Jackson's point. She didn't read it and then ask the attorneys for their response, their argument, their statement. She just read it, and then she says, okay, mistrial.
But to you folks, your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So
Just sua sponte is the word, isn't it, Lainey? Sua sponte, which means on her own without any input. And that's the point that Yannetti and Jackson are making is, hey, wait a minute. We should have had some chance to argue. In a second, you're going to see the looks on their faces.
thank you so much for your service. Okay.
All rise for the court, please.
This beautiful shaky camera.
Look at them. They look kind of like, wait a minute. Yannetti looks kind of PO'd. Can I say that on YouTube? He looks PO'd, doesn't he?
Mm-hmm.
Well, he looks like, what? I'm like, what the hell just happened?
They should have been given an opportunity to say something. And that's what he's thinking. You can't see Jackson's face because Karen's standing in front of him. Look, you can kind of see Jackson's eyes there. You can see it in his eyes. Look at his eye. Am I reading too much into it? We had that
He looks
body language.
angry.
We had that body language in the other day who was, excoriated in the comments. So am I reading too much into it to say that Jackson looks kind of PO'd, doesn't he?
He does. I mean, that's not a nice looking face, friendly face.
Yeah, I don't even know. I mean, I can't even imagine what's going through their head right now.
But, it is weird though that the note said charges. So maybe because the note said charges, she didn't think to pull, to ask them if they were deadlocked on certain charges or not, because the note said charges.
Mm-hmm. And that's why I think it might. Sorry, I was just going to say, I think that's why it was an oversight and not really intentional.
Well, I agree with you, Lainey, but at the same time, I'm not a judge. I don't have a procedure book. I knew a judge fairly well at one time, and his office was lined with books from seminars and procedural manuals. And, the thing that distinguishes a mere mortal attorney like myself and a judge who should know and should have, foreseen, and who, when the jury was deliberating for 5 days, had, I hate to say this, but you had 5 days to go over the manual and figure out, Jesus, if it's a mistrial, here's what you do. And for me, as a mere mortal who doesn't know anything beyond the few cases that are on my desk, I think you're right, Lainey. I think, it was just an oversight. But at the same time, this is a huge, major trial that just was tried for 2 months. And I think Yannetti and Jackson had a good point that we should have had an opportunity to say something before the mistrial was granted. So I don't know.
Right. And she just cut him off. So did the attorneys ever get to see that last note? That's what I was confused on. Did the attorneys ever see it?
According to the motion,
no.
According to the motion, no, they didn't get a chance to see. We can go back and look at the motion some more, but look at them. Look at them. They both look kind of not happy, don't they? They look really kind of not happy.
He went on his phone to go text someone. Is just like, look into this. What's going on?
I think it's because they were asked at this time right here to look at their books and figure out a good time for them to get together and decide where we go from here. And setting a trial date was the next thing. So we can read more of this. What I wanted to go further into this, and it goes into a lot of background, which the motion is the motion is out there online, so we don't have to go through it all. But a basic point, which I think you brought up before, Yoli. The double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial. So I mean, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was manifest necessity for the mistrial. Here, Karen Reed did not consent to the declaration of a mistrial, and they're citing, even very recent cases rejecting the argument that the defendant consented to the declaration of mistrial because he did not object. No, they have to be given the opportunity, and this is absent the defendant's consent, state and federal double jeopardy protections bar, as a general rule, a retrial of a defendant whose initial trial ends. So, the law is, I don't know, seems like the law is on the side of investigating this more fully.
Well, yeah. So what's going to happen now? I mean, so now the judge has an order out impounding the jury. It just sounds so like she's sending them to the dog pound.
Yeah.
I don't know. It just
Okay.
so,
Thank you for mentioning that. So here, this came out almost simultaneously with the motion, an order of impoundment. The Supreme Judicial Court in Massachusetts has recognized that the safety of jurors is crucial to the fair functioning of the judicial system, and that the justice system owes them the highest degree of vigilance for their personal safety. This case, the judge observed, has garnered significant and divisive attention in Massachusetts and across the nation. The trial was live streamed on local and national broadcasting channels. The proceedings continue to be the daily subject of commentary on various social media platforms. People associated with the case have been charged with intimidation. This court acknowledges that the names of impaneled jurors who rendered a verdict in a criminal case must be retained in the court file and made available to the public. The jury in this case did not render a verdict. However, the court concludes that there is a real and present risk of personal harm to the jurors and to the integrity of their service. And, remember what one of the jurors said in that first affidavit that I read, that they felt intimidated. Consequently, the court finds that the good cause exists to impound the list identifying the names of impaneled jurors in the trial of this case. The court further concludes that there is a risk of immediate and irreparable injury should the list be made available to the public at this time. But this order shall expire in 10 days. So the court will review this. But nonetheless, I mean, so the names of the jurors is being impounded at this time.
So she's keeping it secret
For now. Yeah.
for now.
Yeah.
Yeah.
So
I understand.
So Higgins, I know that they said that they were intimidated by Higgins in the courtroom. Was he in the courtroom?
Yes, apparently he and Jennifer McCabe and some of the Alberts were in the courtroom during. No, I wasn't there, but it's from what I've read and heard. They were all there, and some of the jurors apparently felt intimidated by them. I mean, Higgins is a big guy. He's a big guy. Looks like a fighter, but I guess the next question is, this raises some serious allegations. It raises some serious issues, even though I've never seen anything like it in many years. And I'm just wondering, will the court bring the jurors back either by Zoom or by correspondence or remember, Yoli, in the end of the Murdoch trial, then there were the allegations that Becky Hill, the court clerk, had tampered with the jury because she wanted a guilty verdict, because she wanted to sell her book and make money, all of which failed. Nonetheless, there were allegations that Becky Hill cornered one of the people in the bathroom and made some comments about, don't take this too seriously, et cetera, et cetera. So remember, in Georgia, which is a totally different state, has no precedential value over what happens in a Massachusetts courtroom, but nonetheless, in what I thought was a really unusual move, which I've never seen ever before, they did bring all 12 of the jurors back, remember? And they had that by special assignment. They brought in that retired South Carolina Supreme Court judge who questioned them all. Remember that?
Yeah.
So I wonder if that'll happen in this case. I mean, that's extraordinary.
No, so they brought in another attorney. I heard.
Yes.
And he's a criminal defense attorney, So I'm wondering if they did that because Yannetti and Jackson, Mr. Yannetti and Mr. Jackson, are now going to be witnesses if there's any kind of proceeding. And so they will need a criminal defense attorney for Karen Reed. I
think you hit the nail on the head. I think you hit the nail on the head. I can't think of any other reason that they brought the other attorney in.
Right.
But you're absolutely right. Let's go to the final signature page, and there it is. You've got David Yannetti, you've got Alan Jackson, Martin Weinberg, who is also a fairly well-known criminal defense attorney in Boston. He's represented some underworld figures and others. He's just a very well-known criminal defense attorney. I think you hit the nail on the head that now Yannetti and Jackson have become witnesses, and you can't be an attorney in a case in which you're a witness. And guess who? Do you have the da-da-da sound effect ready? Guess who else is now going to be a witness?
Dun, dun, dun.
The judge?
Judge Canoni. What did she say to those jurors?
Yeah.
What did the note say? What conversations did she have with the jurors? Now, maybe she just said, thank you. I mean, that's typically what that's the judge's role. Thank you. I know it's been difficult for you. But so she's now a witness.
So the other question is also going to be, I think, is that whether she should have told them based on the wording of the note that their moral convictions and deeply held moral convictions or whatever it was should not be a part of this, that you should put those aside and look at the evidence. I'm wondering if she should have admonished them based on that note, but I mean, I don't know. Like, I'm not a judge. I don't have a judge's handbook, but I would have done that. I think I would have done that as one last ditch effort to make sure they understand the judge's rules and to make sure they understand that they're supposed to keep it out. And then if they can't, then it declares a mistrial because these jurors have preconditioned beliefs that they can't be fair.
And there were a total of 3 notes in which she sent them back. So this was note 4. So she probably just figured out throw in the towel. But something wrong happened here. And the motion to dismiss, it's available online. It goes on and on and on and on and on. But the basic point is, hey, if 3 of the jurors have now have come forward to us. We didn't contact them, but they came forward to us and said, hey, we reached a not guilty on count 1, the big one, the second-degree murder, and count 3. How can they retry Karen Reed without looking into this?
Know. They have to look into it. But the other 2 jurors that used an intermediary, well, that's the question I have. Did the other 2 jurors, jurors B and C, did they authorize the intermediaries B and C to talk to the defense attorneys?
Do they need that authorization to be considered in court?
Well, I don't know. I'm just curious if the motion papers say that the jurors, the indirect contact was okay, that, in other words, jurors B and C told these people, would you contact the defense counsel?
I think Lainey raised a good question, and I don't know because this is a unique issue, but I think the answer would be, is there a reasonable expectation of privacy in a Zoom communication where there are multiple parties?
That's kind of what I'm thinking too. I don't necessarily... like when you put Zoom too, I think it's a little bit different because Zoom does warn you that it is recording. I don't know how Massachusetts is, but I know certain states when you're like having a phone conversation, you can't record them. And if you record them, like you can't use that in court because it's illegal. I don't know how Massachusetts is, but I wonder if even like the text messages would be considered something like that, where if they didn't give permission for it to be recorded, that it wouldn't be admissible.
Yeah, that's all a fine point, and you're absolutely right about that. But I think that's a fine point when you're talking about sending somebody to jail for the rest of their life.
True. Yeah.
And also, I think it's a fine point in that, again, I think I think if you read, and Lainey, you were lecturing me the other day on people reading all those warnings and reading all that fine print. And I think if you read all the fine print in Zoom, I think it tells you right there that there's no reasonable expectation of privacy. And
Yeah.
as good of
'Cause
as good of a question that is, I don't know. It's out there. So all the
Well,
more reason.
yeah,
that's only B and C. A was a direct communication by a juror to Jackson and Yannetti. Now, I found it a little bit troublesome that, contrary to what you may have heard elsewhere, including on some major television stations and networks, contrary to what you've heard there, and you can go right down in the comments and say, Mr. Myers, we have not heard from the foreman. We have A, B, and C have not indicated that they were the foreman. So
they could have been, but it doesn't. You'd think they would say that.
you're right. It could have been, but you would think that. And the other thing that I heard on TV, and you can go right down in the comments and say, Mr. Myers, we heard that the judge appointed the foreman. No, I mean, we heard that it was the other way around. We heard that the jurors appointed the foreman. No, the judge appointed the foreman. Remember that towards the end, right after the very last evidence, the judge herself selected the foreman. But I heard it reported on one of the big TV stations. Oh, no, the jury appointed the foreman. No, it's not. But,
so is that what happens in Massachusetts, that the judge appoints the jury foreman?
Not usually, no, not in my experience. Not in my experience. But like yourself, I try largely civil stuff. I've done some criminal stuff. The only other little teeny tiny little, and I mean teeny tiny little detail that we need to get in here is hot off the press. Mr. Lally was asked. Mr. Lally was asked for his response, and he said that he is examining the motion prior to giving his response, and he looks forward to setting a new trial date on July 22nd. So even after reading after reading what we just discussed, the prosecutor, Adam Lally, is looking forward to setting a trial date on July 22nd.
I can't believe that. He's just like, yeah, we're gonna do it anyway. I'll look into it. I'll let you know when I look into it. But we're just gonna keep going.
I found it so hard to believe that anybody would convict beyond a reasonable doubt on the evidence that they produce.
Well, that's a whole other subject, but I agree fully. Yeah, I agree. Yeah. It's just
strange.
Well, all right. Unless you guys have a final closing note, I guess I would just say, yeah, we're thinking out loud here of maybe doing our first ever live on the 22nd. I guess, Lainey, you can't participate because you're having something else going on that you will not be able to participate. But I decided maybe this should be our first live. So if it fails as miserably as the first live I attempted without you.
If hopefully we'll have to see where things go, but hopefully you guys watching at home will see me in chat, and hopefully if I'm feeling well enough, I'll be able to help navigate some stuff, maybe try to supervise from bed, be in bed completely immobile with my mouse, just trying to help monitor and help moderate.
And then again, at the last minute, I might just say, forget it and throw in the towel. And
maybe I can live stream with you. It just hit live stream to my audience. And
yeah. If you're welcome, you're invited if you want to come. Absolutely. But I tried a live once with our friend, Forensic Frenzy. It was no reflection on her, because she's a very nice person and she really knows her stuff. And I love having her as a guest. She's been really busy with other stuff in the last month. It was a disaster.
It's hard.
It was a total disaster. Thank you, Comcast.
It's definitely hard, even because not only Comcast, not only internet problems. It's funny because when we're watching YouTubers and streamers, when little things happen, it's how do you mess that up? But even just getting that everything to work correctly when you press live can be hard.
Oh, then you have all these trolls that are just, if you're not watching the chat, there's some kind of argument going on or something.
Yeah. I've noticed even some of the people that have been doing this much longer than I have. I've noticed even some of the people that are really experienced at this, even they have issues with the internet, with whatever the gremlins that are out there. I mean, just think of all the stuff that has to happen for these things to go well. I mean, I'm in one locality, Laney, you're at another locality, Yoli, you're way over there on the left coast, we're on the east coast. And for all this to come together somewhere, bouncing off the satellites and all that, and through the wires. And I was looking at the mess of wires outside my office the other day. It looks like just these wires are going everywhere.
I have a bunch of wires there too.
So it's like, it's not a perfect technology. It's really, I hope they have, when they actually do get around to sending people to Mars, I hope they have better technology than we have here in my little office.
Well, it's better not to use Wi-Fi. I think if you're doing a live, you should be plugged in.
Yeah, well, but it still goes through all those wires.
I was gonna say I was plugged in today and we had some technical difficulties. It's like just the stars have to be aligned, the universe has to be aligned.
And the universe, as is evident in this case, the universe is never aligned. It's always in retrograde.
YouTube is watching.
Well, I'll have to see what I have.
Okay, guys, let's call it a day. Please be kind. Please be respectful, whether you're in the grocery store or the parking garage or the gas station. You don't know what the other guy's going through, so please be polite and respectful to everyone, and especially down in our comments. We don't mind if you disagree, but if you personalize it against anyone, we legally are obligated to. So, okay, people, thank you for joining us, and have a great day. You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions.
That's that.
That's that.
And that's that.
What a mess. I hope that Lally can take some time and focus on the present and what's happening right now instead of getting ahead of himself looking towards the future.
I can't see this case being retried. I don't
I can't either. It was so like the prosecution just threw a whole bunch of stuff. And everything they did was just disaster after disaster. I mean, you had the guy throwing away his phone after he was told not to. You had the cups, the solo cups with the blood. You had Jennifer McCabe getting, making faces and very combative. You had, it was just the inverted.
And all of the stuff you just mentioned and 10 times more was all brought on the stand by the prosecution, by the state of Massachusetts. The Commonwealth of Massachusetts brought all of those witnesses on the stand. It was their witnesses. And it's like, Jennifer McCabe, did she really have that much to offer other than being really aggressively angry? Brian Higgins, did he really have all that much to add? And I'm just trying to think, strategically, if you're trying a case like this, I don't know. You really need all those witnesses? Do you need them all?
Yeah, the fight in Aruba, they investigated that, called witnesses about the fight in Aruba, but yet they didn't go into the house and talk to people and investigate, look inside the house, right? They didn't, did they? They didn't.
Whole thing, no. And the thing about Aruba was the two girls apparently one John O'Keefe had been good friends with her, and then he got to be friends with little sister, and then apparently either he was drunk and stumbled into her, and she stumbled into her, and Karen saw that and was not happy, or what you'd read in the paper there was a huge long article in one of the Sunday publications in Boston that had indicated that it was a little bit more than came out on the stand, that maybe Karen Reed actually saw them in a very romantic kiss. And so, I mean, if they were trying to establish motive through that, I don't know. I think the whole thing backfired. And so, I mean, I don't know. I guess Lally was trying, in retrospect, it's easy. And I'm sitting here in my nice air conditioned office in the summer. So I'll grant Lally that. But, looking back on it, why did we have to bring all that stuff in that was just spurious?
Yeah. I don't know.
It's just like, I mean, relationships are messy, and, interpersonal relationships between different people are complicated. But that doesn't mean you kill them. I mean, how many people have you gotten into a screaming match with? It's like, you don't know what you're talking about. You don't know what you're talking about. It's like, you don't turn around and kill them.
I'm running out of fingers.
And then go looking for them. Yeah, exactly.
I mean, that's every day, multiple times a day, people have these things,
Yeah. Couples argue. So, I guess my point is, why did all of these 74 witnesses have to go on the stand? And I'm only putting myself in Mr. Lally's shoes, or I think he was just being told what to do by Michael Morrissey and others. If you have something negative in your case, you don't want the other side to bring it up, because that's going to look bad. That's going to look bad. So you want to bring it up yourself and diffuse it. But boy, there was just so much of it in this case.
They brought up things that they thought were positive, which turned out to be just negative.
No, like a person that I know well who works in my office sometimes asked me just this question: why did they bring all this stuff up? Why did they bring all this stuff up? And I said, well, I'm a personal injury attorney, and I've tried a number of personal injury cases over the years. And if my client had an injury, a valid, legit injury, and we have physicians that'll testify that it was caused by the accident, and here are the symptoms. But I find out that my client did have another injury maybe 18 months before. I want to bring that up on the stand. I don't want to hush it and not mention it, and then have the defense bring it up later. The insurance people are just going to pounce on it and say, see, Mr. Myers tried this case for 3 days, and he never told you that his client was already injured before, and this is no more than just a continuation of those symptoms. And I don't know if you've been in that situation, Yoli, but I'll ask my client after we go through the whole litany of my client's accident, injuries, effect on their lifestyle. Say, oh, you did have an accident before, didn't you? Yes. But that was 18 months ago, wasn't it? Yes. And you hadn't treated for that for a long time, had you? No. And you'd returned to full duties after that previous accident, hadn't you? Yes. Point being that if there's something negative in your case, you want to bring it up yourself to show that I'm an honest attorney, my client is an honest person, and we're going to deal with it. Now, when the insurance people come up, think of something else.
Right.
Think what you're going to do.
Happen. I mean, the worst part is if they don't tell you about the injury.
They better.
I know. That's just.
Yeah. I mean, and that's the thing, too, is that people might not even say anything to their attorney because they don't want to get in trouble.
Well, before trial, we're going to find that out because of something called the CIB in New York, the Central Index Bureau. Anytime that there's a claim for an injury, it goes into the CIB in New York. And then anytime you put a claim in, they spit it out often to the defense, to the insurance companies first. But yeah, before you might not find that out until you're negotiating the claim, but you're going to find that out before trial. Mm-hmm. And I always ask for it in discovery. And if they don't give it to me, I file a motion to compel. So yeah, you're going to know that before trial. My only point was if there's negative stuff, you're going to bring it up yourself, but that much negative stuff? I mean, I don't know.
Well, it wasn't even pointed out by the prosecution. It was pointed out by the defense, the negative stuff.
Yeah.
And
well, the prosecution put these witnesses up that were just, they were just like, who's that character in Peanuts that always has the dirt swirling around in Pigpen? witnesses were all like Pigpen, and they came on the stand, and Lally tried to clean them up.
It's just bad. And I didn't watch the whole thing. I mean, I only watched certain. Oh, and the text messages by and Proctor's he's not getting paid for his leave now, I heard.
Oh,
my
yeah.
goodness.
In all seriousness, we should have mentioned this, and we were remiss in not mentioning this during the body of this program, was that, yes, they had a hearing. The same day that this motion came out, there was a hearing in Massachusetts, and they've suspended him without pay. They can't fire him because of all kinds of union regulations, but he's been suspended without pay.
Well, that makes me feel better, because that those kinds of communications are just doesn't. It's not professional, and it just shows what kind of person he is.
Yeah, it shouldn't be happening in any workplace, let alone law enforcement.
Yeah, we went down that rabbit hole in one of our previous episodes, but I'll only say I think. I don't think they should ever retry this case, but I think they could retry it without Proctor, although, they tried to get a lot of the evidence in through Bucinic, but I guess they figured that if they didn't put Proctor on the stand, that then Jackson and Yannetti would bring him in. And so, hey, Elizabeth Little wasn't on this motion.
Oh.
The other attorney. The female attorney that was there for the whole case, she was not on this motion. That's interesting. Well, I guess she had other cases to work on.
Yeah, I mean, or she didn't really have the contact with the jurors, so.
And wouldn't she be conflicted out in that?
Probably.
In that Jackson did have a communication, and now he becomes a witness if this goes further, and she's in the same firm, and theoretically they draw a Chinese wall, but that.
No, I don't. I think she would be conflicted out, probably.
Yeah, I think you're right. Yeah. But anyhow, so her name wasn't on this, and they brought in the third. Poor Karen Reed has to have like 3 high-paying attorneys at 3 different firms.
Crazy.
Wow. All right, guys. Thank you.
Okay.
Thank you.
I'll be watching for new developments.